Hello everyone, we will now discuss Republic Act 8353 or the Anti-Rape Law of 1997. Under Section 2 of the said law, it states that the crime of rape shall hereafter be classified as a crime against person under Title 8 of Act Number 38157 as amended, and accordingly there shall be incorporated into Title 8 of the same code a new chapter to be known as Chapter 3 on Rape. So as a review, we will tackle how rape is committed under Article 266-A. So rape is now committed by a man who shall have carnal knowledge of a woman under any of the following circumstances: through force, threat, or intimidation, or when the offended party is deprived of reason or otherwise unconscious, by means of fraudulent machination or grave abuse of authority, and when the offended party is under 12 years of age or is demented, or even though none of the circumstances mentioned above be present. Number 2, by any person who under any of the circumstances mentioned in paragraph 1 hereof shall commit an act of sexual assault by inserting his penis into another person's mouth or anal orifice, or any instrument or object into the genital or anal orifice of another person. So, with that provision on how rape committed, we will now proceed to prove the evidence of rape. So, under said law, Article 266-T on presumptions, it says there that any physical overt act manifesting resistance against the act of rape in any degree from the offended party or where the offended party is so situated as to render her or him incapable of giving valid consent may be accepted as evidence in the prosecution of the acts punished under Article 266-A. So what does Article 266-D mean with this presumption? It means that Article D of RA 8353 appears to have modified the nature and degree of resistance required of the victim of rape, meaning the resistance of the offended party need not be strong and tenacious anymore. In fact, half-hearted resistance or a mere act of trying to resist the sexual assault may be accepted as evidence in the prosecution of rape, or any overt act manifesting resistance from the offended party is admissible in evidence to prove the crime of rape. And with that, the resistance could be any degree such as light resistance, simple resistance to the sexual assault would thus suffice to prove rape, thus making the task of proving rape easier for the prosecution. With this reminder, let us now hear the report of Eloisa Militar.
In this topic, we will discuss Article 266-D, Presumptions in Cases of Rape. Article 266-D states that any physical overt act manifesting resistance against the act of rape in any degree from the offended party or where the offended party is so situated as to render him or her incapable of giving valid consent may be accepted as evidence in the prosecution of the acts punished under Article 266-A. Evidence accepted in prosecution of rape is as follows: any physical or overt act manifesting resistance against the act of rape in any degree from the offended party, or when the offended party is so situated as to render him or her incapable of giving consent. To understand further the application of this provision, we will now discuss the case of People v. Estrebelia with GR number 71464. The facts of the case is as follows. Romeo Estrebelia was accused of having carnal knowledge with Joy Alcala. The results of the psychiatric and psychological examination shows that Joy Alcala was a mental retardate whose mental age is below her age which is 13 years old. The physical and genital examination showed that she had sexual intercourse with a man. However, there was no complete penetration as the hymen was still intact. Joy's brother testified that he saw Estrabella having carnal knowledge with the victim. Hence, he punched the accused. Accused denied the allegations and said that he was only talking to Joy when Joy's brother punched him. In Estrabella's defense, he used to see Joy playing with her private parts by inserting her 2 fingers. Hence, he did not rape the victim based on the findings that there was no tear in her hymen. So the issue of this case is whether or not there was insufficiency of evidence to render him guilty of rape. The court held that no. Under Article 266-D, it is presumed that a person's incapability to give consent may be used as an evidence to the crime of rape. It has been established that Joy is a mental retardate. Sexual intercourse with a woman who is deprived of reason or one who is weak in intellect to the extent that she is incapable of giving rational consent to the carnal intercourse constitutes rape. The medical findings confirms that the testimonies of Joy's brother. There is still rape even though the hymen was not lacerated. Furthermore, Joy's offer of no resistance does not mean that she consented, for she does not know how to comprehend properly, given that she is a mental retardate. Relating this case to Article 266-D, the case of Joy falls on the second category, where such evidence may be accepted in the prosecution of rape. Joy, being a minor and a mental retardate, is incapable of giving consent to the carnal knowledge. The prosecution may use this information as evidence to the crime committed by the accused.